In litigation, a common tactic is attempting to prove how someone acted on a specific occasion by showing how they generally behave. For instance, arguing that because someone is generally careless, they must have been careless today. This desire to use past conduct to demonstrate present conformity immediately runs into a fundamental evidentiary conflict. We must distinguish between two concepts: character evidence and habit evidence. Character evidence, governed primarily by Federal Rule of Evidence 404 subsection A, deals with broad personality traits, like being honest or being a reckless driver. Generally, the rules bar using this general disposition to prove action in conformity therewith. Conversely, Federal Rule of Evidence 406 addresses habit evidence. This concerns specific, routine, and near-automatic responses to recurring situations. Our goal in this section is to clearly delineate when evidence of routine behavior is admissible to prove action today, and when evidence of general disposition is strictly barred by the rules of evidence. We now turn our attention specifically to character evidence, governed by Federal Rule of Evidence 404 subsection A. The core principle here establishes a broad prohibition against using disposition to prove conduct. Rule 404 explicitly states that evidence of a person's character or trait of character is not admissible for the purpose of proving that on a specific occasion the person acted in conformity with that character or trait. This is the classic definition of inadmissible propensity evidence. Character evidence describes a broad, generalized personality trait, such as being generally honest or generally reckless. The rule strictly forbids using that broad label to argue, therefore, this person must have acted dishonestly or recklessly today. The law views these sweeping generalizations as too unreliable and too prejudicial to be used as proof of action in conformity. We must focus on the specific act, not the general personality assessment. While Federal Rule of Evidence 404 subsection A broadly prohibits using character to prove propensity, this prohibition is not absolute. There are several critical exceptions where character evidence is indeed admissible. First, evidence regarding a witness's character for truthfulness or untruthfulness is permitted, usually for impeachment or rebuttal purposes. Second, in criminal cases, the defense may introduce evidence of a pertinent character trait of the accused or the alleged victim, effectively opening the door for the prosecution to respond. Third, we have the admissibility of evidence of other crimes, wrongs, or acts, often remembered by the acronym MIMIC, for purposes like proving motive, intent, absence of mistake, identity, or common plan or scheme. Understanding these exceptions is vital context because they show the limited ways the law allows general character evidence. However, Rule 406 provides an entirely separate, specific pathway for proving conduct based not on general disposition, but on established routine conduct. The previous chapter concluded by noting that while character evidence is generally barred under Rule 404, Rule 406 offers a distinct and separate pathway specifically for routine conduct. Now, let us turn directly to that rule. Federal Rule of Evidence 406 explicitly addresses habit evidence. It states that evidence of a person's habit or routine practice is admissible to prove that on a particular occasion, the person acted in accordance with that established habit or routine practice. This is a crucial distinction. Unlike the broad character evidence prohibited under Rule 404, Rule 406 permits proof of specific, repeated conduct. This rule functions as an explicit statutory exception, carved out because established routine behavior is considered far more reliable and probative of immediate action than general disposition. We are shifting focus entirely from general personality traits to automatic responses triggered by recurring situations. To successfully admit evidence under Rule 406 as habit, two critical elements must be rigorously established. First, we require specificity. The conduct in question cannot be a general trait. It must be a specific, reflexive response triggered by a specific, recurring stimulus. Think of it this way: it must be an if X, then Y scenario. For example, always locking the door immediately upon leaving the house is specific. Contrast that with merely being a careful person. Second, the evidence must demonstrate frequency and near uniformity. The action must be so regular, so invariable, that it approaches automaticity. Courts look for near certainty, perhaps 90% or more of the time, that the person acted the same way when presented with that exact stimulus. Sporadic or occasional compliance will fail this test. If the conduct is merely occasional, it risks collapsing back into inadmissible character evidence. These two hurdles, specificity of the stimulus-response loop and near invariable repetition, are what separate admissible habit from excluded propensity evidence. Let us solidify these requirements with a concrete illustration, focusing on the stimulus-response loop we just defined. Imagine a commercial truck driver involved in an accident while leaving a loading dock. To prove the driver acted negligently, the opposing counsel might try to introduce evidence. If they argue, the driver is simply a careful person, that is inadmissible character evidence, speaking only to general propensity. That statement fails the specificity test immediately. However, if the evidence shows that every single time this driver prepares to pull out of that specific loading dock, they reflexively check their left mirror, then their right mirror, and then their rearview mirror 3 distinct times, that is habit evidence. This is a specific, repeated action triggered by a specific stimulus, exiting the dock. The action is not merely being careful. It is the precise, automatic sequence of mirror checks. This specific, near-uniform routine is precisely what Rule 406 permits us to introduce to show conformity on the day of the incident. We just saw how the specific, automatic mirror check qualified as habit. Now, let us pivot back and explicitly define what we are contrasting that against: character evidence. Character evidence is fundamentally different because it describes a person's general disposition, their moral quality, or an overarching personality trait. Think of terms like honesty, general carelessness, or inherent peacefulness. This evidence is inherently broad. It does not describe a specific reaction to a specific trigger. Rather, it speaks only to general propensity. Because the law views propensity evidence with suspicion, as it risks unfair prejudice by suggesting someone acted in conformity with their nature, character evidence is generally excluded under Rule 404(a), unless one of the narrow exceptions we previously discussed applies. This broadness is the core reason for its exclusion, setting it apart from the precise routine of habit. We established that character evidence is broad disposition, while habit is a specific, near-automatic routine. The critical question courts must answer is where the line is drawn between these two concepts. This line is defined by the litmus test of frequency and particularity. Think of it as a spectrum of reliability. On one end, if evidence shows a person acted a certain way only 3 times out of 100 attempts, that is too sporadic. It suggests general behavior, making it inadmissible character evidence, likely excluded under Rule 404(a). However, if the evidence demonstrates near uniformity, say, the person acted a certain way 99 times out of 100 in direct response to the exact same stimulus, that regularity elevates the conduct to admissible habit under Rule 406. The difference is not just in the action itself, but in the statistical certainty of its repetition in response to the trigger. This threshold of near invariability is what separates propensity from routine. We just established that near uniformity is the key to habit evidence. Now, let us apply this critical distinction directly to a classic bar exam negligence scenario involving a traffic accident. Imagine the plaintiff alleges the defendant ran a red light, causing injury. If the plaintiff attempts to introduce evidence that the defendant generally, always speeds in traffic, this evidence is inadmissible. Why? Because always speeding is a broad statement about the defendant's general disposition or character for carelessness. This falls squarely under the prohibition of character evidence, Rule 404A, proving propensity. However, consider this contrasting evidence. The plaintiff introduces testimony that the defendant always stops completely at this specific intersection, regardless of traffic, because of a specific past accident there. This evidence is admissible under Rule 406 as habit. The reasoning is precise. The stimulus, approaching this specific intersection, triggers a highly specific, near-automatic response, a complete stop. This is not general carelessness. It is a routine, specific reaction to a known hazard, meeting the threshold of near invariability we discussed. To conclude our analysis of this crucial evidentiary distinction, let us synthesize the core takeaway from our examples. Remember the fundamental split: character evidence, governed by Rule 404, deals with broad personality traits. When you attempt to prove someone acted a certain way today simply because they are generally careless or generally honest, you are proving propensity, and that evidence is almost always excluded. In sharp contrast, habit evidence, governed by Rule 406, is admissible precisely because it avoids the pitfalls of propensity reasoning. Habit evidence focuses on routine conformity, a specific, near-automatic response triggered by a precise stimulus. Think of the difference between being a careful driver and always checking mirrors 3 times before exiting a loading dock. The entire admissibility hinges on one critical factor: the degree of specificity and the near invariability of the past conduct. If the conduct is specific and nearly automatic in response to a recurring trigger, it is admissible habit. If it is merely a general statement about disposition, it remains excluded character evidence. Master this distinction, and you master a frequent bar exam topic.